For a lot of movements, having an interest group is one of the very first things that's necessary in order to pursue an avenue of action and change. And so when the NAACP was established in 1909, African Americans now had an organization that would fight to protect their rights and regain the rights that they had lost some years before. Beginning in the 1930s, the NAACP decided that it was time to challenge the separate but equal doctrine that was established by Plessy versus Ferguson.
The case of Plessy versus Ferguson had allowed segregation under the 14th Amendment as long as the facilities were separate and equal.
And pretty soon in the South, separate definitely became unequal.
NAACP becomes a very active organization looking at some way of challenging these court cases.
And the targeted education, more than anything else, is sort of the key turning point that had to be worked out in order for African Americans to have a much more equal footing in this country.
They set up the Legal Defense Fund to start testing cases in the courts to look to overturn Plessy.
What they do is they send out little groups of these attorneys and law students to the various NAACP chapters in different cities looking for cases that would play well.
And in 1950, the Topeka, Kansas chapter of the NAACP agrees to get behind a test case.
They found a group of parents who were willing to try and enroll their children at schools so that they could be turned away. And then once the schools turned away the families could then file suit.
In this group, there's only one dad. His name's Oliver Brown.
A man named Oliver Brown who tries to enroll his third grader,
Linda Brown, and she's 9 years old.
Using the argument that she has to make a long walk to a bus stop and then a long bus ride to go to a black school, whereas the white school that's in her neighborhood is only 7 blocks away and she can walk from home to school.
Ultimately, of course, Linda's denied admission.
This was a place where they had a very good plaintiff and they had a very good case because it was so demonstrably easier for her to go to this school right down the street as opposed to a school all the way across town. They also liked that he was a male. They thought, right or wrong, that the Supreme Court of the United States was more likely to respond well to a male lead plaintiff than it was to a female lead plaintiff. All of these things were things that they thought might make Oliver Brown, in his case, a good one to bring forward.
Brown versus Board of Education of Topeka, Kansas, that ultimately gets challenged all the way up to the Supreme Court.
So what happens in this case is it's actually not just one case. It's 5 cases. It's a case in Kansas, it's a case in Washington, D.C., it's a case in Delaware, it's a case in South Carolina, and it's a case in Virginia.
When the court has several challenges on a similar policy based on a similar argument, oftentimes they'll hear it as a lump sum class action suit.
A class action suit is when you have a number of different individual cases that are asking the same question from the court, but with different sets of facts behind them. The court said, well, we can answer this question once and apply it to all of these facts.
They set their sights on the Equal Protection Clause of the 14th Amendment.
If you're going to make this claim that separate but equal is always unequal, what you really wanted to back that up with was not just common sense, but to get the weight of academic opinion behind it.
An African-American psychologist had done a series of experiments with black children.
The psychologist takes a black baby doll and a white baby doll.
Then researchers would follow what they did with the dolls or which dolls they selected to play with and what roles they gave those dolls in their play.
The students showed a great deal of disdain and anger and dislike of the black dolls and chose a preference for white dolls.
And the NAACP uses this as social science evidence to suggest that these separated educational facilities are creating deep-seated feelings of inferiority.
The Chief Justice at the time was Chief Justice Vincent.
And he was a segregationist, and he was pretty conservative.
The court couldn't reach a decision.
In the absence of a clear and authoritative decision, which they didn't seem likely to get at that moment in time, the solution was to wait.
They took a break at the end of their session,
And then Chief Vincent gets very, very sick.
and he died.
President Eisenhower appoints Earl Warren to be the Chief Justice of the Supreme Court.
Warren comes in not as a lawyer, not as someone that had served on a court, but as a governor.
I think he was patient, and I think he was a really good politician, and I think he was a really good persuader.
What he wants them to do is to be able to issue a unanimous opinion of the court, 9-0, that segregated schools have to go.
Not a 5-4, not a 6-3. No doubt that this was something that the court believed in and believed in strongly.
They reheard the case in December of 1953, and then with Earl Warren there, they were able to reach a unanimous decision.
In a unanimous decision,
The doctrine of separate but equal is not okay.
Separate but equal, as defined by Plessy versus Ferguson under the 14th Amendment Equal Protection Clause, was unconstitutional and overturned.
separate is inherently unequal.
Southern states were very slow to implement any kind of decision or any kind of change in the law.
So the court knows this, and they actually write in the language of the opinion that they want the parties to come back the next year. The court hears Brown again in Brown 2 in 1955 and finds that nothing had been done.
The first Brown case doesn't really desegregate the schools.
In very strong language, the court adamantly says, desegregate with all deliberate speed.
If they didn't make it happen, it wasn't going to happen, and the court would be a toothless tiger. It would look like it couldn't do anything.
For the court to actually step in and say that this must be done and that they were going to oversee it and that they were going to have the plan to desegregate the schools and that it should be done with all deliberate speed, this was something that was unprecedented at the time.
I don't think we should underestimate, too, the importance of the Eisenhower administration's response.
You have Eisenhower sending in the National Guard.
Without that, the court's authority would have been nothing.
So Brown v. Board is very important precedent. It establishes the language, the groundwork. But because the court is reactive and doesn't really have an effective tool for policy implementation, it's a long time before we feel the real effects of a desegregated South.